Yesterday, I started giving a little real estate primer, and it was up to the point where the seller prepared contracts of sale, seller's attorney forwarded them to the purchaser's attorney. There was some negotiation, discussion, and once the buyer is content and satisfied with the contract that was received, the buyer sends back the contracts signed along with a deposit check. That's the down payment. The down payment is typically 5 to 20%, 5 to 10% of the contract sales. Say historically, the amount has been 10%. The more money that's put down, conceivably, the greater the likelihood is that this qualified candidate, the buyer, will secure a mortgage and forge ahead to the close. Now, once the contract is received by the seller's attorney and seller review any changes or modifications that have been made to the contract and ultimately sign that contract, and the deposit is placed in escrow, set aside until the closing date. The attorney for the seller can't use it or spend it or do anything with that deposit until the close. Then it becomes the money of the seller. Now, what does the buyer do? What does the seller do at this point? The buyer starts two processes. There's two parallel sets of tasks that occur. The attorney for the buyer searches the title to look for liens, violations, encumbrances, things that are on title that need to be addressed. And if anything like that is observed, the buyer's attorney prompts the seller's attorney to correct or cure those items on behalf of the seller. The second process that takes place is that the buyer has to secure a mortgage through a mortgage bank, a lender, an institutional lender, and there'll be an entire process with that. And I think that's where I'm going to stop for today. So the two processes take place: title and ultimately clearance and the obtaining of a mortgage by the buyer. If you'd like to speak about real estate with me, like to discuss anything at all to do with contesting real estate, buying real estate, selling real estate, FrankBrunoLaw.com.